Welcome to this week's lecture on sentencing. So let's imagine it's the winter of 1989. I am 10 years old. Many of you are nowhere near being born yet. And Justice Blackmun is getting ready to announce the U.S. Supreme Court's ruling on the case Mistrada versus the United States. Now, just to give you a little background, John Mistrada is a guy who admits in federal court that he's been selling cocaine, and using the new federal sentencing guidelines formed by the U.S. Sentencing Commission, Mistrada is sentenced to 18 months of incarceration in a federal prison. Now, Mistrada doesn't like this very much. He doesn't think it's fair, and so he files an appeal and argues that the U.S. Congress unconstitutionally bestowed its legislative powers on the commission, which was created as part of the judicial branch of government. In other words, the delegation of powers principle states that one branch of government cannot transfer its authority to another branch of government, and therefore the sentencing guidelines formed by the commission are, according to Mistrada, illegitimate. So, in hearing Mistrada's case, the U.S. Supreme Court needed to rule on whether the new federal sentencing guidelines were indeed an example of an unconstitutional transfer of powers between the judicial and legislative branches of government. So, let's go back in time to 1989 and listen to Justice Blackmun announce the court's ruling.
The opinion of the court in number 877028 in a companion case, Mistrada against the United States, will be announced by Justice Blackmun.
These cases concern the constitutionality of the Sentencing Reform Act of 1984. And that act created the United States Sentencing Commission as an independent body in the judicial branch with power to promulgate binding sentencing guidelines. Guidelines have been issued and they are challenged here. Similar challenges in federal courts throughout the country have resulted in diverse and opposing rulings. And because of that conflict and the great importance of the issues in the administration of this country's criminal law, we granted the respective petitions of defendant Mistrada and of the United States for certiorari before judgment in the Court of Appeals for the Eighth Circuit. In an opinion filed with the clerk today, a too long opinion, I fear, we hold that the sentencing guidelines are constitutional, and specifically that Congress did not delegate excessive legislative power to the Commission and did not violate the separation of powers principle by placing the Commission in the judicial branch or by requiring federal judges to serve on the Commission and to share their authority with non-judges, or by empowering the President to appoint Commission members and to remove them for cause. Therefore, in this litigation, we affirm the judgment of the United States District Court for the Western District of Missouri. Justice Brennan joins all of the opinion except footnote 11. Justice Scalia has filed a dissenting opinion.
We hold that the sentencing guidelines are constitutional, and specifically that Congress did not delegate excessive legislative power to the Commission and did not violate the separation of powers principle. So, Mistrada lost the argument, and the 1984 Sentencing Reform Act was further upheld by the court, particularly its formation of the Sentencing Commission and that commission's sentencing guidelines. It's important to note that the U.S. Sentencing Commission in the 80s did some subjectively great things. Before these guidelines were formed, judicial discretion in federal sentencing was largely unconstrained. Discretion leads to disparity, and so offenders who committed similar acts were receiving widely different sentences, and this leads to distrust and uncertainty in our criminal justice system. I think back to warnings by people like Thomas Hobbes and Beccaria. Hobbes asserted that people need to feel respected by a governing authority in order to buy into or support its authority. And Beccaria cautioned that punishment must be swift, certain, and severe in order to work effectively as a social control. By certain, he meant that we, the people, need to have a pretty good sense of what the consequences are. If different people get different consequences, our certainty wanes. And Beccaria, a big believer in determinate equal sentencing, would point to that and remind us that punishment won't work if it is wielded in a way that seems careless, unpredictable, or unfair. While the creation of federal sentencing guidelines helped address sentencing disparities in the US, it's important to understand their limits. The majority of crimes in this country are adjudicated through state courts, not federal ones. And each state has its own authority to handle sentencing in its own way. So let's talk a little bit about common terminology and concepts associated with sentencing. Remember, while sentences are imposed by courts, sentences are carried out by correctional agencies and institutions, which makes sentencing an important topic to understand as we venture further into our study of corrections. A sentence is a penalty imposed by a court after a defendant has been convicted of a crime by a jury, judge, or through a guilty plea. A sentence prescribes an offender's movement through the correctional system, which can include institutional and/or community-based responses to the offense. Now, sentences of incarceration can be either indeterminate or determinate. An indeterminate sentence is a sentence in which the number of years a person may serve in prison is presented as a range rather than a fixed number, such as 5 to 10 years in prison. Now, if you support this approach to sentencing, it probably means that you don't necessarily think that every offender guilty of a similar offense should be treated in exactly the same way. You prefer to leave some room for rehabilitation and correction and give the system some discretion to release someone early if they've earned it, or if the institution has some other interest in their release, such as freeing up space for the holding of someone more violent or more dangerous. There are at least two common arguments against this kind of sentencing. Firstly, granting this much discretion to judges and parole boards can lead to social biases becoming further entrenched in our justice system. Secondly, it's important to consider a victim's perspective in relation to this kind of sentencing. It's important for some victims that they have a clear and certain sense of how long their offender will be detained. So the imposition of an undetermined period of incarceration and the threat of parole can mean that some victims feel a continuous need to be involved in their case, fighting against the release of their offender, and again retelling their story and asking for justice. In other words, indeterminate sentencing can make it harder for some victims to feel like the case is truly closed and they can move on. A determinate sentence is a sentence in which an offender is given a set number of years to serve in prison rather than a range. So state lawmakers typically set caps on determinate sentences, meaning that a court cannot impose sentences for certain offenses beyond a certain amount, such as 20 years for a first-degree robbery conviction. One major concern regarding this type of sentence is that it offers less motivation for offenders to earn release through good behavior and personal rehabilitation. So by granting the correctional system less power and discretion over the sentence, institutions are then less empowered to incentivize institutional order as well as personal growth on the part of the inmates. A mandatory sentence is different from a determinate sentence. A mandatory sentence is determined by lawmakers, not the court, and it's used to eliminate probation as an option for a specific offense, as well as set a minimum prison term for that offense. In other words, a state or a federal legislature can mandate that if a certain crime occurs, such as distributing X amount of a narcotic, The convicted offender must serve a specific number of years in prison. Mandatory sentences can be determinate or indeterminate. What makes them distinct is that they are mandated by statute, further constraining judicial discretion. A couple of additional terms related to sentencing which are relevant to corrections include concurrent and consecutive sentences. It's not uncommon for one criminal incident to involve more than one criminal charge. For instance, let's say that a defendant was driving while impaired and caused a wreck which killed 3 people. Now, this is one criminal incident, but it involves 3 criminal charges. In these kinds of cases, a convicted offender can be required to serve multiple sentences at the same time or concurrently, or they can be required to serve multiple sentences sequentially, which is what we call consecutive. If the sentences are concurrent, the offender in my earlier example will serve time for all 3 of the deaths at the same time. In other words, if he's sentenced to 10 years for each charge, he'll still only serve 10 years for all 3 deaths. If, however, the sentences are consecutive, he will serve 10 years for one, then 10 years for another, and then 10 years for another. Another important concept that I think we should cover this week is civil commitment. So, civil commitment refers to the involuntary hospitalization or incarceration of someone deemed unsafe to live in free society. Civil commitment is rooted in 2 legal principles. Those are parens patriae and police power. Translated as parent of the country, parens patriae asserts that the government has a right and responsibility to take guardianship of citizens who are unable to effectively take care of themselves or who lack a capable guardian. In addition, the principle of police power refers to the right of the state to control behavior and enforce order in a way that will benefit the health and safety of its people. This principle draws its power from the 10th Amendment, which permits states to act in protection of the safety, health, and welfare of itself and people in ways that the Constitution does not either prohibit or limit to the federal government. So, all of this to say, a sentence in a criminal court is not the only way in which our government can incapacitate someone. Our civil system can also incarcerate, and this does sometimes happen in our prisons. So, let me tell you a little bit about James. James is an inmate I used to visit at the federal prison in Springfield, Missouri, many years ago. James had been arrested and sentenced for a federal crime. However, he had already completed his sentence by the time I met him in that federal prison. So he was still in prison even though his sentence was complete. James had a severe mental illness, and his crime involved a sexual offense against a child. So it was complicated for me visiting James. On the one hand, I was pretty outraged by the idea that someone could be held in a federal prison after they had completed their sentence. I hadn't studied criminal justice yet, so I had frankly never heard of this before, and I was really surprised that it was legal in our country. As I kept visiting with James, however, he would talk more and more and more about children. He was obsessed with children. It was really clear to me that he would have no ability to stay away from children if he were released back into society, especially without heavy supervision. And if that were to happen, it seemed inevitable to me that he would harm another child. James suffered from delusions, he was extremely paranoid, and his behavior just wasn't rooted in rational thinking. Though I was horrified by what he'd done, I had a lot of compassion for James But ultimately, I agreed with the system that it would have been morally unthinkable to just release James back into society. That does not mean, however, that I believe he belonged in a federal prison. He had served his time for his crime, and in my view, he needed to be moved to a treatment institution with safer and more supportive conditions for someone like him. So, why was the government allowed to continue confining James in a prison? Isn't this an abuse of power? Isn't this perhaps even arguably a form of double jeopardy? The answer lies in another ruling of the U.S. Supreme Court, this time in the case of Kansas v. Hendricks. This is a 1997 ruling. Leroy Hendricks had been incarcerated in the state of Kansas for committing the crime of child sexual molestation. It's important to note that Hendricks had a long history of this behavior, and he'd admitted that this behavior was not going to stop as long as he was alive. Upon the completion of his sentence, the state of Kansas decided to just hang on to Hendricks, assuming for good reason that more children would be harmed if he were released. Hendricks argued that this violated his rights to due process and violated standards protecting him from double jeopardy. The U.S. Supreme Court, however, disagreed with him in a 5-4 decision. So note that it was a split decision, asserting instead that because civil commitment is an act of the civil court versus the criminal one, Hendricks' rights were not being violated. Kansas had the authority to continue his confinement. Now, I expect this topic to be controversial for you. I hope it is. Granting the state this kind of authority over our liberty is not something any of us should take lightly. However, there are some offenders who suffer from mental health conditions that we just can't effectively control. And it's hard to argue against the state's responsibility to protect us from people like James and Hendricks, as well as protect James and Hendricks from being in situations where they can't control their compulsions. Regardless of how you feel about this practice, it's an interesting glimpse into the interaction between how we treat crime in our country and how we treat mental illness. And that's a nice segue to problem-solving courts, often called specialty courts or treatment courts. So let's talk a little bit more about those. Problem-solving courts could be described as correctional courts. So rather than moving the offender into the correctional system after sentencing, the court extends its supervision of the offender while trying to address the offender's specific criminogenic factors and needs. So these courts often work with probation officers as well as various community resources to offer a community-based sentencing option that diverts offenders out of prison and focuses on rehabilitation and accountability versus punishment. These courts tend to focus on specific issues or offender populations. For instance, a drug court will focus on offenders with drug-related crimes or substance use issues. A mental health court will focus on offenders with a diagnosed mental illness. A veterans court will focus on offenders with a history of military service. So there are a lot of these types of courts active in the US now. In Greene County, Missouri, we have a few of these, including a DUI court and a mental health court. Now, the efficacy of these courts can vary depending on the way they are operated, as well as the number and quality of accessible resources in the community of implementation. However, generally speaking, these models are highly successful and mark an interesting evolution of our court's approach to sentencing and involvement in corrections.